the work in question, or 3, disqualify the prospective awardee. Subsection B, in the event that a subcontractor is disqualified under this ordinance, the general contractor, construction manager, or other lead or prime contractor shall not be permitted to make any type of contractual claim against Plymouth Township on the basis of a subcontractor disqualification. Section 8, public review process. Subsection A, the contractor responsibility certification for a firm identified in a notice of intent to award, subcontractor list, and subcontractor responsibility certifications shall be made immediately available to the public for inspection through a publicly accessible website or other comparable means. Subsection B, during the public review period, any person or organization may protest the contractor or subcontractor for failing to meet applicable requirements of this ordinance or on any other relevant grounds by submitting a letter with supporting evidence to Plymouth Township. Subsection C, the Plymouth Township determines that a contractor or subcontractor responsibility certification contains false or misleading material information that was provided knowingly or with reckless disregard for the truth, or omits material information knowingly or with reckless disregard for the truth. The firm for which the certification was submitted shall be prohibited from performing work for Plymouth Township for a period of 3 years and shall be subject to any other penalties and sanctions, including contract termination, available to Plymouth Township under law. A contract terminated under these circumstances shall further entitle Plymouth Township to withhold payment of any monies due to the firm as damages. Subsection D, a procurement contract subject to this ordinance will not be executed until all requirements of this ordinance have been fulfilled and until contractor and subcontractor responsibilities, certifications, and subcontractor lists have been made available for public inspection for at least 21 days. Section 9, severability, effective date. Subsection A, if any provision of this ordinance shall be held to be invalid or unenforceable by a court of competent jurisdiction, any such holding shall not invalidate any other provisions of this ordinance, and all remaining provisions shall remain in full force and effect. Subsection B, this ordinance shall become effective in accordance with the Home Rule Charter and the general rules of the Commonwealth of Pennsylvania, and shall take anticipatory administrative action in advance as shall be necessary for the implementation of this ordinance. Subsection C, the requirements of this ordinance shall not apply to contracts executed prior to the effective date of this Act, except that the exercise of an option on a contract covered by this ordinance shall be deemed to create a new contract for purposes of this ordinance. Ordained and enacted by the Council of Plymouth Township on Montgomery County, Pennsylvania, this 12th day of July 2010, Council of Plymouth Township by Vince Gill, Chairman.
Okay, we heard the ordinance presented by our solicitor. I'd like to make a motion to approve the ordinance. Do I have a second?
Second.
Second by Mr. Renner. Are there any comments or questions from council?
I want to go back to actually I have a couple of questions, but things were never answered. The first paragraph, the council recognizes there is a need. I asked before where we've had problems, where we had a need for this. Secondly, what is the criteria for the integrity and ethics of a business? Who makes that decision? The other thing is, where is the township now from its how business, how they distribute their labor problems with their employees? I don't believe that's our responsibility. I want people I know that has a grievance, enforceable grievance procedure, as mentioned here, is a union. And the same thing with the apprentice program. Again, I'm not opposed to the union working. I'm opposed to this ordinance. And the last thing, I'll say it again, if Mr. Gillen, you're sincere about this, about being the quality of work the township gets, then this should be stricken to $10,000 because that's our bid threshold. And that means that anything that we bid, if we're sincere about this, should be $10,000.
The one question, Mr. Simpson, regarding the section that refers to business integrity and things along those lines, These are already existing requirements under the Municipal Procurement Act. What that allows the township to do, or what it allows any municipal entity to do, is to take into consideration issues that may have arisen with a particular business at a particular time in order to disqualify them. If a business, for instance, had in the past been convicted of attempting to bribe a public official, if they had been convicted or they had had complaints about using illegal, undocumented workers, and that had been proven against them, that is what is in this section. That is an example of something that the business integrity, you would be able to disqualify them for that purpose.
Mr. Clark, I think you take ahead. This includes the fact that, I don't have a problem with peaceful protest, but threatening, violent harm to personal property, to me, is unethical. And I think would have a reason for rejection. Again, whose decision is that?
Well, it's the decision of the township.
Is there anything in place that as a councilman, if I'm not happy with something, is there something in place you can put in writing? I mean, it's kind of bad.
If there is a company or a firm or an entity that is applying, has submitted a bid to do the work on a public works project here in the township, and any council member or effectively any member of the public is aware of information that they believe should disqualify that firm or entity from doing work in the township, they're always permitted to bring that forward. They're always permitted to use cases and say that this person should be disqualified, or this entity or firm should be disqualified. Obviously, in public bidding, there is a significant amount of case law in the Commonwealth. I, as your counsel, would advise what has been determined by the courts to be a basis for disqualifying some firms, and what has been determined not to be the basis. And I would advise you, but ultimately the decision is made by counsel.
It just seems very well.
Any other comments, questions from council?
Mr. Chairman,
Murray.
thank you for the floor. Timing is everything. After 40 years of residence and living within this township, plus years, I'm still up until the workshop in May. I had no idea that it was so bad, and our contractors that performed for the township performed so badly prior to this being introduced in May. Timing is everything. This ordinance will eliminate the use of local contractors, business people, and residents within our own township. In principle, I stand behind this ordinance. We have to walk the walk and talk the talk. In reality, when you're voted into this position, you're here to support the township, number one. And the people of this township and the people that have served in as contractors and local business people deserve our support. I'll leave it at that.
Any comments from the audience?
I didn't get an answer to the 25,000. This is sincere. Why don't we make
I did last month. I believe the $25,000 is a good threshold because it addresses Mr. Eisenberg's concerns to a point that it doesn't disqualify the local small businesses that are bidding the contracts. And B, the $25,000 threshold is what's in place for prevailing wage, and you're going to be paying an employee that prevailing wage rate after $25,000. I think it's in the best interest of our taxpayers and our tax dollars to pay a worker a prevailing wage rate that's going through a formal training program and is a skilled worker.